Professor G.S. Bajpai serves as the Vice Chancellor of National Law University, Delhi. Sir's career spans over 30 years of professional experience as an author, researcher, teacher, and administrator. At the instance of the Honorable High Court of Delhi, Professor Bajpai was appointed as amicus curiae for certain cases, and his report in Curran versus State introduced the concept of a victim impact report and the procedure for calculating and granting compensation. Notably, Professor Bajpai is also credited to have conceptualized the novel paradigms of victim justice, victim jurisprudence, and wrongful prosecution in the Indian context. Sir, given your expansive career and your work being done in the theme, I'd like to invite you to shed some light on the area of rehabilitation, where we are, and what you see as the way forward.
Very good morning to all present, and I acknowledge the gracious presence of Honorable Justice Tara, Judge High Court Delhi, and also my thanks go to Mr. Kundu for having me today here, Mr. Joshi, Secretary DCPCR, and I have a lot of people to really acknowledge for their presence today, and all the persons who are present today on this occasion, where we are having this very important conversation on the POCSO's 10 years. Friends, I have only a couple of things to say because I am aware that in the technical sessions, you are going to take up some very important issues pertaining to the POCSO and especially the focusing on rehabilitation. The first thing to me is very important as I would begin my conversation on that I'm on some larger questions because we are observing 10 years of POCSO. What does it mean? To me, I'm always fascinated to the one branch of legal research, that is the impact assessment of any law. An impact assessment is something which we do not know much in this country by way of any objective criteria. So when we are observing 10 years of this law, it is very important for us to empirically assess the success and failures of this act. Two very important reports are in the context. Recently released report by Vidhi gives a lot of ideas in terms of the stories of success and failures of POCSO. Huck's report also, Bharti Ali's report is there, which provide us a lot of insights as to where we are actually failing. But going to all those things, there are a couple of ideas. My first thing is that the journey of POCSO has a history, because we have realized through different international instruments that the rights of child are very, very important, one. Second, they have not been given the due priority in terms of laws and adjudication processes in the country. And third, there is a need to have a specialized mechanism to really address the victimization and all kinds of sufferings rehabilitation needs to the victims of crime. Keeping those things in mind, we have brought several laws to this country, Juvenile Justice Act and POCSO, of course. But while Juvenile Justice Act was focused on the offending part of the children, this act was a victim-centric law. So victim-centric law has its, again, we need to understand the nature of law. I always believe, I am a law professor, I always go to the jurisprudence of the law. We have perhaps forgotten that the nature of POCSO law is very, very different. We have somehow reduced this law to a penal law, merely penal law. And we have created a mechanism of punishing people through this law. Many of you must be knowing the Supreme Court's harsh commentary on the practice of providing death penalty to the accused and the convicted people in the state of Madhya Pradesh. I am not on that because this is one way of probably misreading the law. So nature of law means this law is a victim-centric law, where we need to sort of do more on this thing. I was conversing with the chairperson, and I said I'm a little surprised that POCSO is in discussion and we are not looking at the trial, evidence, conviction, and all those things. Rather, we are focusing on rehabilitation. So this is the true. I congratulate you for reading this particular dimension of this law in that sense. So first of all, that we need to probably make a victimological reading of POCSO. I always say this is high time that we should start reading our laws from victimological lenses. So far, we have been reading these laws from punitive lenses. That is the whole problem is happening. So we have a system which is more keen to send the people behind the bar rather than providing solace, assistance, rehabilitation mechanisms to the victims of crime. And therefore, this 10-year audit and impact assessment of this law is something I am very inclined to do, and I have already said to the chairperson that this is something we can do in ground. And we need to understand that where are the bottlenecks and where are we failing? Are we giving the required rehabilitation and restoration ideas and strategies to the victims of crime on the ground or not? And secondly, the extent to which this act and the associated mechanisms have been successful in preventing victimization in sexual offenses, because probably this act is focused on protection and also prevention. So somehow we are lacking more and more on that, and probably we have made it another criminal law. So because people think that when arrest is made, case is put to the court, justice is done. Justice has several shades. I remember Urvashi's work, CSJ work, which we have done together. And they have come out with a unique conceptualization of justice, meanings of justice to the people and the stakeholders. So the law is same, but the meaning of justice to the victim, meaning of justice to the accused, justice to the community are very, very different. And we have a duty to sort of fulfill all these expectations through the law. That is another thing. So I am on victimization, prevention, and protection to be more and more focalized as far as the adjudication of this law is concerned. And I'll come to a more core question for which I do not have an answer. But I need to understand, because recently we have seen the India Justice Report has come out. And they are actually raising a very fundamental question, which is equally true in case of this particular law. They are saying that capacity of the criminal justice system to enforce the law is not sort of incommensurate with the tasks which are provided to these agencies. So we need to understand whether POCSO machinery, POCSO regime has that required capacity to fulfill the expectations which are the part of this law or not. So when capacity is lacking, the goals shall not be or will not be achieved. That is the one problem. There is a mismatch. You have given an ambitious task to the limited machinery. I'll come to the machinery aspect, which I have just discussed in the morning. I am of this view that we have two types of laws. One, laws which are addressing social questions, social issues, like this is also a social legislation in a way, our Domestic Violence Act, SC/ST Act, a lot of other acts, juvenile justice. We have, placed them in a sort of a bracket of social legislation. Unfortunately, in this country, the state of enforcement of social legislation has consistently been very, very poor for want of various reasons. Now, for instance, coming to this law, you will find that on the one hand, we have provided a criminal aspect to this law, where we have classified the offenses, where we have given role to the courts, special courts, and all that. We have also given a wider role to the victims and families, where their assistance, rehabilitation, restoration, compensation, their all kinds of measures of assistance will be provided. This aspect requires a lot of non-police intervention. We have made this act as if the police would change the destiny of this nation and the children we have probably eliminated the scope of non-police intervention from the POCSO law. So if you are talking about those services, those needs which are to be addressed through this law, mapping of those needs, delivering of those services, rehabilitation requirements, lot of non-policing measures are needed. However, we have not provided a clear-cut framework and the role of those agencies. That has been passed, support person. Somebody in the morning presentation, it was support person. As if we want it to be a sort of sideline kind of thing, sidelight of the act. This is the highlight of the act. But so I think unless you create the matching machinery to fulfill the non-policing objectives in POCSO, this aspect will continue to be in a kind of neglect. And it is happening. Therefore, I am saying that it is the time where we need to sort of focus on the core aspect, which is the restoration and rehabilitation through this law. However, the term rehabilitation or restoration are not very explicitly mentioned. But if you make a conjoint reading of rules, different rules, Rule 20, especially 2020, they are providing a whole scope. I find that there are 7 kinds of very important needs. So sometimes we are looking at only the compensation as a sole solution. Compensation is a pecuniary, a monetary arrangement. But I think the impact of victimization is required to be sort of addressed and mitigated through multiple ways, when not necessarily money or pecuniary help would be of assistance. So I think we need to go back to 1985 UN Declaration on Victims of Crime and Victims of Abuse of Power, where they have clearly identified the important needs which arise as a consequence of victimization. So for instance, in victimological parlance, we talk about the 2 kinds of consequences. One which is a direct consequence, which would give rise to the medical needs and other kinds of. I am also sort of saying which is important, that there is a secondary victimization. Primary victimization is by the offender or by the offending pursuits. Secondary victimization, the term secondary victimization I am using, which characterize the experiences of the victims of crime when they deal with the criminal justice agencies and experience the hardships and other kinds of negative experiences. So unfair dealing by police, prosecutor, and at other places, other medical agencies. Secondary victimization has not been adequately mapped as far as child victimization in this case is concerned. So there is a hidden facet of victimization as far as POCSO victims are concerned. And there is absolutely no mechanism to mitigate such kind of victimization. So 7 kinds of needs which would arise. Of course, we understand the mental health needs. There is a passing reference in the rule about. But problem is that it's fashionable to say that there are mental health needs. But who is interested with the function of mapping these mental health needs? And in this country especially, the issue of mental health is completely absent. Probably we don't have that capacity. Medical needs you can address because there is a doctor. But mental health needs, and in this kind of victimization, it is the mental health needs which become more and more prominent. Protection and other kind of shelter and other kinds of housing, those needs are very, very important. And also the education, because in the morning we have been shown the dropped out. Obviously there would be an impact on education thing. And family becomes another important point of victimization. They have multiple concerns associated with the victimization of children. And probably we need to create a comprehensive victim assistance strategy as far as POCSO victims are concerned. And I think there was a great opportunity, it is my view, in Rule 2022 to come out with a comprehensive victim assistance strategy. I am also a part of Victim Support Asia, and I am also the Secretary General of World Society of Victimology. And I had the occasion to look at the neighboring country, Sri Lanka. They have very recently created a National Victim Assistance Authority in Sri Lanka. In all other countries, it is there. In US, we know that NOVA has been functioning for a long, long time, National Organization for Victim Assistance. And they have a very important role, like we have NALSA. This is high time in this country to formalize the process of victim assistance at all levels. Because on the one hand, you are creating laws which are very ambitious in nature, and you are saying the state will compensate, you are saying that all kinds of things, but the institutions are missing. So laws are happening, institutions of laws are not there. So creating a mechanism like National Victim Assistance Authority at the central level and state level and district level, like we have a legal, so a lot of work is being done by District Legal Service Authority at the moment. But I think there is a time that we should own victim assistance as a priority as far as criminal justice system is concerned. So that would provide us a lot of support in terms of institutional way to address these things. I'm aware that the report said whatever number of victimization is taking place, half of them are of very grave nature, penetrative sexual victimization, which means that the psychological consequences like anxiety, depression, and amnesia, and all kinds of things are very severe. But as I have said, those things remain unaddressed in most cases. So probably very good focus at the moment remains on the issue of compensation in this act. That is my whole issue. Compensation disbursement has been made lot easier, I would say lot efficient, because a special court can take cognizance, our report can be made, interim compensation is possible, compensation under 357A is possible. However, other forms of assistance which are very crucial to the victim rehabilitation is concerned, they are missing. And I think there is I would further reiterate that there is a scope to sort of introduce a framework in the rules which we have revised. So unless we make those changes in rules 2020, and later on those rules can be updated to incorporate some of these ideas, the things won't change. And lastly, I would say that again, I'll reiterate that this is the time to do a systematic empirical study on the impact assessment of POCSO to underscore the core issue of rehabilitation, which is very, very important. Thank you for your time.